Welcome to the next episode of the Lakeside Show. I'm Zerji, the host today, and our beloved co-host here, Mrs. Jacqueline, Mrs. Saira, and Mrs. Janie. Azim will be joining us online today because he's not feeling well. We often see in television drama series statements like, "I'm gonna sue you for my emotional damage or mental losses." But in reality, is it that easy to bring a claim to psychiatric injury? That's what we will be finding out today in this episode. Before we start, let me introduce to you what is psychiatric injury. Psychiatric injury is basically a medical recognized conditions that disturb normal functioning of mind with or without overt physical symptoms. Lord Adner described it as a nervous shock caused by an appreciation of terrifying events that agitates one's mind. Psychiatric injuries is indeed significant in tort law because it protects the victims, although it's limited. It follows the principle of compensations that aims to recover victims to the pre-injury state, but the courts always exercise cautious and reluctance due to the complexities and evolving understanding of duty of care. In Malaysia, we refer to UK jurisdictions and law, which means similar principle applies in Malaysia too. And both countries recognize psychiatric injuries as a cause of actions. Moving on, when it comes to a psychiatric injury claim, it is important for the plaintiff to prove their psychiatric illness. This means that they have to prove their mental illness or neurosis or personality change that recognized by the medical professionals is caused by the defendant's traumatic events. However, it is important to differentiate from emotions such as worry, grief, and sorrow. There are exceptions where mere emotion that leads to physical or psychiatric illness such as heart attack, hypertension, or anxiety could possibly claim. In order to let you all understand better in the development in psychiatric injuries of tort law, we'll break that into 4 parts, which is formal law, primary victims, secondary victims, and lastly, the future development. The formal law is illustrated in the case of Victoria Railway Commissioners and Torts 1883. In this case, Mr. and Mrs. Collins was riding on a horse-drawn buggy. Due to the negligent act of the gatekeeper, the gate was opened. The horse buggy was almost hit by the train, and this caused a nervous shock to Mrs. Cottlers, but there is no physical injuries. However, the Privy Council held that a nervous shock unaccompanied with a physical injury is too remote to claim for the negligence acts of the gatekeeper. Referring to this case, it clearly illustrated that it is impossible to recover psychiatric injury without physical injury. The reason why court is being hesitant and reluctant to award the claim is because they want to prevent the floodgates and also prevent any fraudulent claims. Besides that, it is difficult for them to assess the intangible injuries and proving the causations. They also have to protect the defendants for any possible emotional disturbance.
To start off, we will first discuss the law governing primary victim in psychiatric injury claims. Primary victims are those who are basically affected or involved in a particularly dangerous or critical events. It is also those who suffer physical injury and subsequently develop psychiatric illness as a result. Let us first explore the court's initial decision and stance regarding this claim. Initially, the court did not allow claims of psychiatric injury without the direct physical injury itself. As mentioned previously by Zerji, it is the same reason why the court was reluctant to allow compensation for psychiatric claims without a proof of the injury itself. This was the only law that governed primary victims during that period of time. However, the court changed its perspective when the case of Delio and White and Sons happened. This was the first case where shock in absence of physical injury was recoverable. The plaintiff was a pregnant woman who was working at a bar. The defendant had crashed his van into the bar that she was working at. The crash had resulted to a miscarriage experienced by the plaintiff due to the shock that she felt. The defendant was held liable as his actions had made the plaintiff fear for her own personal safety. Justice Kennedy, who was a judge in this case, mentioned that if fear is produced by physical effects, then it should be able to receive the same damages as fear that is produced by actual physical impacts, as both eventually lead to the same outcome. It has been established that a primary victim would only need to prove that physical harm was foreseeable for the claim to be successful. This means that there was no need to prove how the psychiatric illness that occurred was foreseeable. As long as the physical harm due to a certain action or omission was foreseeable, then it is possible to recover compensation. Page and Smith's case is one example of a successful claim regarding a primary victim. This case had clarified for plaintiffs who do not suffer any form of physical injury but are within the area of physical risk due to defendant's negligence and as a result suffer psychological injury can actually take action against the defendant. In this particular case, the plaintiff, who was in recovery for some sort of a fatigue syndrome, was met in a minor car accident with the defendant. The accident had triggered the plaintiff's fatigue syndrome to become chronic and permanent, which had prevented him from working. The defendant was held liable as it was foreseeable for a kind of personal injury as the result of the accident. Due to this foreseeability, there was no need to establish that psychiatric injury was foreseeable as it is already sufficient. The law for primary victims had further developed in the year of 2001. The case of Guterres and Guterres had actually brought up the issue of whether a primary victim owes a duty of care to the secondary victim. In this case, the father, who is the plaintiff, had suffered from psychiatric illness after rescuing his son, the defendant, from a car accident that happened due to the defendant's negligent driving. The claim failed as it was held that primary victims do not owe a duty of care to secondary victims. This principle was practically put into place to prevent litigation between family members, as it also would be unfair to impose liability on primary victims who are also suffering from their own self-inflicted injuries. If this case were to be allowed, the floodgates of cases where a family member suffers from psychiatric illness due to another family member conduct would be open. This would overall just affect the relationship between family members, as some would try to go as far to recover compensation by using their shock as an excuse.
Moving on, we'll now be talking to you about secondary victims. So who are secondary victims? Secondary victims are essentially those who suffer from psychiatric harm as a result of witnessing harm to others. There are several elements that needs to be proven when it comes to cases regarding secondary victims. We'll also be looking at two cases which involve secondary victims, namely Hembrook and Stokes 1925 and McLaughlin and O'Brien 1983. First off, we'll now look at the case of Hembrook and Stokes 1925. So what happened in this case was that the defendant left his lorry unattended on a steep, narrow street, and the plaintiff's wife was slightly away from the children when she realized that the lorry was actually driving towards her direction. She was really concerned about her children's safety as they were away from her at that point of time. As a result, she suffered from nervous shock and ultimately died after being told by a bystander that a child with matching descriptions to her own child has been injured. So the court held that it is actually reasonable for the mother to feel nervous when she saw the lorry driving towards her direction, and in combination with the bystander's statement, it was reasonable to think that something bad has indeed happened to her child. Nonetheless, this was a failed claim because the requirements by the secondary victim was not met, unfortunately, and she did not witness the case personally on the spot, and she only heard about it from a bystander. There was a lack of direct witnessing of the event, and this lacking of direct witnessing of the event eventually became a crucial factor when it came to the court's decision. Next up, we have the case of McLaughlin and O'Brien 1983. So what happened in this case was that Mrs. McLaughlin received the news of her family's involvement in a car accident, which led to her husband's death and her children suffering from severe injuries. And she actually arrived at the accident scene after the immediate aftermath. However, the court still allowed her to recover from her psychiatric injury. This case marked a significant expansion in the scope of recovery for secondary victims because it introduces additional requirements and factors that needs to be considered beyond the strict requirement of witnessing the event firsthand. And the courts actually also recognize that the immediate aftermath of an accident can be an exception that allows recovery. So the courts actually consider several factors, which includes proximity in time and space, the close relationship between the secondary victim and the injured party, and lastly, the shock resulting from the sudden knowledge of the event. Next up, we have very specific criteria, also known as the Alcott criteria, that needs to be fulfilled when it comes to cases involving secondary victims. So let's explore these criteria and a landmark case that shapes the current law. So Alcott criteria are actually 4 key requirements that secondary victims need to meet in order to succeed in a claim for psychiatric injury. So first off, we have a close tie of love and affection to a primary victim. So this actually refers to a blood relationship such as parent and child, and also close relationships such as spouses. Secondly, we have witnessing the event with their own unaided senses. Means is that the secondary victim must personally witness the tragic accident either by seeing or hearing it at the scene. Third, we have proximity to the event or its immediate aftermath. So what essentially means is that secondary victims must be in close proximity to the event or its immediate aftermath and react immediately to the tragic situation. Lastly, we have psychiatric injury must be caused by a shocking event. So secondary victims must experience a sudden appreciation of sight and sound of a horrifying event that intensely affects their mind. Now I'll pass it on to Janie, who will be talking to you about the Alcott's case.
Now, let's look at the case of Alcott versus Chief Constable of South Yorkshire 1992. In this case, the plaintiffs seek for compensation for psychiatric injury after witnessing their friends or relatives die in a stadium crash incident that occurred due to the negligence of the defendant in allowing an overload of people into the stadium, causing 95 deaths. The House of Lords was to determine whether there was a duty owed to those who did not physically witness their loved one in the tragic accident but yet still developed psychiatric injury. They also consider whether it was reasonably foreseeable for the defendant to foresee such damage caused to the plaintiffs. The House of Lords drew a distinction between primary victims and secondary victims. For secondary victims, the claim for compensation has to meet all 4 Alcott criteria we discussed earlier. Only when all requirements are met can the claimant succeed in claiming monetary compensation from the defendant. In this case, of the Alcott and the other victims, they failed to meet most of the Alcott criteria and therefore could not claim monetary compensation from the defendant. In summary, the current law for secondary victims in psychiatric injury claims requires to fulfill all 4 requirements of the Alcott criteria. And these criteria emphasizes the close tie of love and affection, personal witnessing of the event, proximity to this event or its immediate aftermath, and the psychiatric injury being caused by a shocking event. The case of Alcott versus Chief Constable of South Yorkshire 1992 played a significant role in shaping the current law and highlighting the importance of meeting these criteria for a successful claim. There also have been cases where secondary victims successfully claimed compensation for psychiatric injury. One of the cases is Hens versus Barry, where Barry was found negligent in driving recklessly, causing Hens to develop a recognized psychiatric injury, morbid depression, while witnessing a bloodshed accident involving his husband and children. Another example is Boardman versus Standerson, where Standerson negligently banged on an infant while reversing his car, causing the father to suffer nervous shock upon hearing the infant scream. We also have a Malaysian case, Zainab versus Mari Mutu, where Mari Mutu's negligent driving resulted in the death of the plaintiff's daughter. Zainab witnessed the accident and suffered shock, leading to sickness for nearly 2 years. However, there have also been cases where claims by secondary victims failed. One example is McFarlane versus Caledonia, an Australian case. In this case, Caledonia was held negligent for a fire on a vessel, which caused McFarlane to suffer a psychiatric injury while rescuing the others. The claim failed because the defendant did not owe a duty towards the plaintiff, as they were not blood-related nor in a close relationship. thus not meeting the requirements of the alcohol criteria. An exception to the general rule regarding secondary victims is seen in the case of Barber versus Somerset County Council 2004. In this case, Somerset County Council was held in breach of its duty towards its employee Barber. Barber had been suffering from stress and depression due to an overload of work and leading to 3 weeks of absence. Despite raising the issue with management, no actions were taken. The Barber's psychiatric injury worsened, and as a result, he had to leave his job and could only find part-time work. The House of Law held that employers should have at least reached out to Barber after 3 weeks of absence, and either reduce his workload or provide assistance. The guidelines from Court of Appeal were approved, although the House of Law reversed that decision and restored the trial judge decision, as they believed that statutory requirements should not be treated with force. These cases highlights the varying outcomes for secondary victims in psychiatric injury claims, while successful claims demonstrate the recognition of harm suffered by secondary victims. Failed claims illustrate the importance of meeting the outcome criteria set out in the outcome case. Additionally, the exception related to the duty of care towards employees emphasizes the responsibility of employers to address workplace stress and provide the necessary supports. These cases contribute to the evolution landscape for psychiatric injury claims for secondary victims.
In the case of Chadwick and British Railways, 1967, the plaintiff voluntarily helped rescue victims of a severe train crash and subsequently suffered from psychiatric illness due to witnessing the horrific scene. The court held that compensation for psychiatric illness was recoverable if the plaintiff had no special relationship with the direct victims and was in clear present danger. The judge did not consider whether the plaintiff feared for his own life, deeming it irrelevant in this context. However, the question of compensation for emergency service workers as rescuers has been subject to different outcomes. In the case of White and Chief Constable of South Yorkshire Police 1999, police officers who had been present at the tragedy sought compensation for psychiatric injury. The Court of Appeal initially allowed their claims, considering them as primary victims. However, the House of Lords overturned this decision and denied the police officers' claims. Lord Steyn made several significant points in the White case. He addressed the floodgate argument, questioning why relatives were denied compensation while policemen could claim damages for doing their duty. He rejected the argument that liability could arise from the employment relationship of the officers and concluded that a duty of an employer not to cause physical harm does not imply a duty not to cause psychological harm. He also highlighted concerns about extending compensation to other professions, such as doctors and hospital workers, and emphasized the unfairness that police officers would receive better treatment than bereaved relatives. Lord Hoffman, in the Robertson case, concluded that the plaintiffs, including police officers, were not primary victims. He highlighted that an automatic duty not to cause psychological injury does not arise from an employment relationship. He expressed concerns about the problems in defining who should be classified as a rescuer and the potential unfairness perceived by the ordinary person. Moreover, in the case of Hale and London Underground 1992, the imposition of a duty of care on the defendant for creating a situation that invites a rescuer was examined. This case raised questions about the fairness of holding the defendant responsible in situations where rescuers put themselves in danger. Further considerations and implications arise from such cases. A mere bystander refers to someone who is present at the scene of an incident but is not directly involved. However, it is important to note that mere bystanders do not fulfill the requirements for successful claims. For instance, in the case of Borhill and Young, 1943, a pregnant fishwife indirectly witnessed a deadly accident involving a motorbike driver. She had only heard the crash occur, but later, upon actually seeing it, suffered psychiatric problems and filed a claim for psychiatric injury. The House of Lords denied her claim, reasoning that the defendant did not owe her a duty of care as she was not his neighbor and that her psychiatric illness was not reasonably foreseeable. In determining the viability of a claim by a mere bystander, courts take into consideration various factors, including how close the plaintiff was to the direct scene of the incident, whether there was a primary victim involved, and the closeness of the relationship between the plaintiff and the primary victim. Aside from mere bystanders, a second category is participating bystanders. These are individuals who are present as well as actively involved in the situation, such as participants in a rescue effort. In the case of McFarlane and E. Caledonia, 1994, the plaintiff was a painter on the Piper Alpha oil rig, although he did not witness the deadly effects of the explosion as he was on a separate vessel. The plaintiff would later claim for psychiatric damage. The Court of Appeal rejected his claim, as it was not reasonably foreseeable that an ordinary person in his position would suffer nervous shock. The court held that the defendant did not owe a duty of care to the plaintiff. Stuart Smith LJ would then emphasize the following: that allowing simple bystanders with no connection to those being harmed to claim compensation would create a test solely based on reasonable foreseeability. This could potentially lead to an influx of claims for nervous shock from individuals who were merely present at the scene of an incident, even if they had no personal connection or involvement. The court wanted to avoid such an outcome, considering it would be unfair and impractical.
What is the extent of recoverability of psychiatric claims? Contrary to the initial focus on physical and personal injury, the law actually recognizes that psychiatric harm caused by damages to property or belongings can actually be compensable. To understand it even further, let's take a look at the case of Atia and British Gas. In this case, the plaintiff had requested British Gas to install a new central heating system in her apartment. However, due to the defendant's negligence, her loft had caught fire upon her return. She witnessed the destruction of her house and her belongings, which had led her to experience nervous shocks. The court had allowed her claim for compensation, also emphasizing that there is actually no doctrine or principles that prevents or limits the recovery of damages for psychiatric harm. Moreover, there are no concerns of floodgates of similar cases overwhelming the courts, as the circumstances in these cases justified the claims for compensation.
Lastly, let's talk about severe criticism and the future development of psychiatric injuries. There is a growing concern that the development in modern medical practice and our understanding of psychiatric illness warrants a reconsideration of the existing legal principle. It has been described as an old-fashioned, inflexible, and unfair law by the Association of Personal Injury Lawyers. Matthew Stockwell also argued that attitude towards psychiatric injury had fundamental change and people no longer expected to show a stiff upper lip. One potential avenue for this reform is the Negligence and Damage Bill. This bill aims to reform the current law related to virulent damage and the conditions imposed on the claimant seeking for damage for psychiatric injuries. The bills intend to place psychiatric injuries arising from the death or physical injuries of others on a similar footing as direct physical harm. However, the bill stopped after the first reading, and it is definitely something that we need to continue pushing for. Another suggestion for future development is the imposition of statutory duty of care on defendants to prevent secondary victims from suffering psychiatric damage due to the death or serious injuries of another person. This would further expand the threshold beyond the immediate shocks, allowing individuals who have witnessed distressing events over a long period of time to seek compensation for psychiatric harm. Besides, Stockwell also argued that the current law has limited recognition of close ties and it can be distressing and intrusive. The law does not currently recognize closeness between siblings, grandparents, grandchildren, civil partners, or friends. He further suggests that the relationship should be acknowledged to provide fair and comprehensive protections for all individuals affected by psychiatric injury. And that's a wrap for today's episode, and I hope you all can get a better understanding on psychiatric injuries. Thank you.